5 tests. That is all it takes. 5 roadside evaluations that most drivers have never heard of, administered in sequence on the side of a road, each one feeding the next, each one adding to a report that ends with your hands behind your back. The officer does not need a breathalyzer to arrest you. He does not need a blood test. He does not need a single piece of chemical evidence. He needs your performance. And if you do not know what those 5 tests are, what they are actually measuring, and what the law says about your obligation to perform them, you are going to give him exactly what he came for. This video is the one you share with every driver you know. Subscribe to this channel right now before we go any further, because after this video, the next one goes deep on what happens the moment the officer decides the tests are done and the handcuffs come out. And those are 2 entirely different legal situations that require 2 entirely different sets of words. Before the 5 tests, you need to understand the architecture of a DUI traffic stop, because officers do not administer these tests randomly. They administer them in a sequence that is designed to build a layered evidentiary record, and understanding the sequence is what allows you to understand why each individual test matters as much as the whole battery. A DUI investigation does not begin when the officer asks you to step out of the vehicle. It begins the moment his lights go on. From that first second, the officer is observing and mentally documenting how quickly you responded to his lights, whether you pulled over smoothly or erratically, how you came to a stop, whether you hit a curb, whether you stopped crookedly. By the time he reaches your window, he has already formed a preliminary impression, and he is now building the second layer, the personal contact observations, the smell of your breath, the appearance of your eyes, whether your speech is clear or slurred, whether you fumble for your documents, whether your hands tremble, whether your responses are coherent. All of that goes into the report before a single formal test begins. The 5 tests you are about to learn are the third layer, the structured evidence collection sequence that converts the officer's subjective observations into a scored, documented, presentable evidentiary record. Each test is a module. Each module produces clues. Clues become a report. The report becomes a prosecution. Understanding that architecture is what makes the refusal of any piece of it so legally significant. The first test is the horizontal gaze nystagmus evaluation. The officer produces a stimulus, typically a pen or small flashlight, holds it approximately 12 to 15 inches from your face, and moves it slowly from side to side while watching your eyes track it. He is not watching to see if you can follow the pen. He is watching for nystagmus, the involuntary jerking of the eyeball, at 3 specific points. Whether your eyes track the stimulus smoothly as it moves horizontally. Whether your eyes jerk noticeably when held at maximum deviation, the far edge of your visual field, for at least 4 seconds. And whether that jerking begins before the stimulus reaches a 45-degree angle from center. 6 clues total, 3 in each eye. 4 or more clues is a positive result under the NHTSA protocol. Here is what the officer will not tell you at that roadside. Nystagmus is caused by dozens of conditions that have nothing to do with alcohol, inner ear disorders, certain prescription medications, neurological conditions present from birth, head injuries, elevated caffeine, fatigue. The strobing emergency lights on the patrol vehicle behind you can directly induce the eye movement the officer is trained to score as evidence of impairment. The HGN test cannot distinguish between alcohol-induced nystagmus and nystagmus caused by any of these other factors. The officer administering it is not a neurologist. He completed a training course. And the test, he is running on the side of a road with a flashlight pen, next to a strobing patrol vehicle, in wind and ambient traffic, bears almost no resemblance to the controlled laboratory conditions under which the original NHTSA validation research was conducted. The HGN is voluntary. Your performance is optional. And everything that PIN would have captured stays out of the report the moment you know that. The second test is the walk and turn. The officer instructs you to stand heel to toe on a real or imaginary line. Keep your arms at your sides, listen to the full instructions before moving, then take 9 heel to toe steps forward, pivot on 1 foot, and return 9 heel to toe steps. 8 clues are scored. Whether you could not keep your balance during the instruction phase, whether you started before the instructions were finished, whether you stopped walking mid-sequence, whether any step failed to meet heel-to-toe contact within half an inch, whether you stepped off the line, whether you raised your arms more than 6 inches from your sides for balance, whether you lost your balance on the pivot turn, whether you took an incorrect number of steps in either direction. 2 or more clues out of 8 is a positive result. Read that list again slowly. You can fail this test by starting half a second too early. You can fail this test by raising your arms 4 inches too high while walking a straight line on uneven pavement in the dark with emergency lights strobing behind you. You can fail this test by taking 10 steps instead of 9 on your return because you miscounted while managing balance, instructions, counting, arm position, and a police officer watching your every movement simultaneously. The walk and turn is classified as a divided attention test, meaning it is designed to overload your cognitive bandwidth and observe the degradation. Under the stress of a traffic stop, with the physiological response of a police encounter flooding your system with adrenaline, every sober driver's divided attention capacity is already compromised before the test begins. The test measures the degradation and calls it impairment. Those are not the same thing. The third test is the one-leg stand. You are instructed to raise 1 foot approximately 6 inches off the ground. Keep it parallel to the ground. Look down at the elevated foot and count out loud. 1001, 1002, until told to stop at 30 seconds. For clues, swaying while balancing. Using arms for balance by raising them more than 6 inches from your sides. Hopping to maintain balance. Putting the foot down before the count is completed. 2 or more clues is a positive result. What the officer does not note in his clue count is whether the pavement surface was level. Pavement shoulders are rarely perfectly level, and even a slight slope measurably degrades single-leg balance performance in healthy, unimpaired individuals. What he does not note is whether the emergency vehicle's light bar was strobing during the test. Balance is a 3-system integration of vestibular input, proprioception, and visual processing. Strobing light disrupts visual processing in ways that directly impair postural stability, regardless of blood alcohol level. What he does not note is your age, your weight, your prior injuries, your current medications, or your neurological baseline. NHTSA's own research documentation identifies people over 50, people more than 50 pounds overweight, and people with back, leg, or inner ear conditions as populations for whom the test results are explicitly unreliable. None of those factors appear in the clue count. The clue count is what goes to the prosecutor. The fourth test is the preliminary breath test, the roadside breathalyzer. The officer produces a handheld device and asks you to blow into it. This is not the evidential breath testing instrument at the station. This is a screening tool, and the legal distinction between the two is one of the most important pieces of information you can carry out of this video. In most states, the results of a roadside PBT are not admissible as direct evidence of a specific blood alcohol concentration in a criminal trial. They are used to help establish probable cause for arrest, not to prove guilt in a courtroom. And in many states, the preliminary roadside breathalyzer is explicitly listed as a separate voluntary test, not covered by the implied consent statute that governs evidentiary post-arrest testing. The officer will not volunteer that distinction. He will present the device as part of the stop's natural progression. He will frame implied consent in broad terms that make it sound like it covers everything he is about to ask you to do. It does not. Implied consent governs chemical testing after a lawful arrest. The handheld device at the roadside before any arrest is a different legal category. The breathalyzer is also scientifically vulnerable in ways the roadside presentation never acknowledges. The device does not measure blood alcohol concentration directly. It estimates it from breath alcohol content using a fixed partition ratio that varies significantly across individuals and fluctuates within the same person based on body temperature, breathing pattern, and metabolism. Mouth alcohol from a recent belch, acid reflux, or residual alcohol in dental work can elevate a reading significantly in ways the standard observation period does not always eliminate. The device produces a number that looks precise. It is an estimate built on assumptions that may not apply to you. The fifth test is one that most drivers have never heard of, which makes it the most dangerous of the 5, because you cannot prepare for what you do not know is coming. The Romberg balance test, sometimes called the modified Romberg or the internal clock test, is not part of the NHTSA standardized battery. It is a supplemental test used by officers trained in drug recognition evaluation protocol, and it is administered when the officer suspects impairment by drugs rather than, or in addition to, alcohol. The test requires you to stand with your feet together, tilt your head back slightly, close your eyes, and estimate when 30 seconds have passed, at which point you tilt your head forward and open your eyes. The officer is observing 4 things: your ability to maintain balance with eyes closed and head tilted back, which eliminates the visual component of your balance system, the degree of eyelid tremors, the degree of body tremors, and how accurately your internal clock tracks 30 seconds. Because central nervous system depressants typically cause people to underestimate elapsed time while stimulants cause overestimation. Here is what makes this test uniquely problematic. Because it falls outside the NHTSA standardized battery, it is not subject to the same validation standards or admissibility scrutiny. Because it is presented as a balance and coordination check, many drivers do not recognize it as an evidentiary evaluation until the results are already documented. And because it requires closing your eyes while standing on an uneven surface with an unfamiliar person standing near you, it produces balance degradation in completely sober individuals at a rate that would be alarming if it were studied under honest conditions. The Romberg test is voluntary. It always has been. And the moment you know that, the moment the officer says close your eyes and tilt your head back, you have the same response available to you as you do for every other test on this list. Here is what makes the 5-test battery more dangerous than any individual test. And it is the piece of the architecture that most people never see until they are looking at an arrest record. The tests are designed to build on each other. The officer does not administer all 5 and then decide. He administers them in sequence, and each positive result lowers the threshold of reasonable suspicion required to justify continuing the investigation. By the time the 5th test is reached, the report already contains clue counts from 2, 3, or 4 prior evaluations. The cumulative weight of those clues in the officer's report, and later in a probable cause affidavit, creates a narrative of impairment that no single test could establish alone. You were unsteady on the balance test. Your eyes showed nystagmus. You miscounted your steps. Your internal clock was off. Each clue reinforces the others. The report reads as a coherent picture of impairment built from 5 independent observations. What the report does not reflect is that each of those observations was generated under conditions that produced degraded performance in sober individuals, scored by a checklist that does not account for the environment, the stress response, the subject's medical history, or the documented scientific limitations of the instruments being used. The sequence is not designed to discover whether you are impaired. The sequence is designed to produce a report that says you are. Here is the legal foundation. And this is the conversation that the roadside stop is architecturally designed to prevent you from having before the first test begins. Every test on this list is voluntary. The HGN, the walk and turn, the one-leg stand, the roadside PBT, the Romberg, none of them are required by law. There is no statute that compels your participation. There is no criminal penalty for declining any of them. Courts across the country have examined the reliability, admissibility, and voluntary nature of this battery and produced a record that would shock most drivers. In United States versus Horn, the Federal District Court conducted an extensive review of the NHTSA research and documented significant limitations in the scientific foundation of the standardized battery. In Schultz versus State, the Maryland Court of Special Appeals identified methodological weaknesses in the original NHTSA validation studies that constrain how broadly the results can be applied. In State versus Witt, the Kansas Supreme Court subjected the standardized tests to scrutiny under state evidentiary reliability standards. In People versus Leahy, the California Supreme Court applied rigorous scientific admissibility review to HGN evidence under the Kelly-Frye standard. In Birchfield versus North Dakota, the United States Supreme Court drew a constitutional line between breath testing and blood testing that confirmed courts take the distinction between different types of chemical and physical testing seriously. Multiple courts have held that deviation from the NHTSA standardized protocol undermines the admissibility of field sobriety test results, and officers deviate from the protocol in the field routinely because the conditions the protocol requires do not exist on the side of a road at night. Drivers who perform the tests have results to challenge. Drivers who declined remove the issue entirely. So here are the exact words. One response that covers every test on this list, every device, every evaluation. every roadside request for a physical or cognitive demonstration. The moment the officer mentions any test, any evaluation, following something with your eyes, walking a line, standing on one leg, blowing into anything, closing your eyes, or any variation of a roadside assessment, you respond this way. Officer, I respectfully decline to perform any field sobriety tests or roadside evaluations. I am exercising my constitutional right to refuse. Am I free to go, or am I being detained? Say it once. Keep your voice level. Do not add anything to it. That single response covers all 5 tests on this list because it is precise, it is legally grounded, and it closes the evidence-building sequence before the first module produces a single clue. Officer, I respectfully decline to perform any field sobriety tests or roadside evaluations. The addition of roadside evaluations to the standard refusal language is deliberate. The Romberg is not classified as a standardized field sobriety test. It falls outside the NHTSA battery. Officers who administer it sometimes avoid the phrase field sobriety tests specifically because drivers have been coached to refuse that category. Adding roadside evaluations closes that linguistic gap and puts your refusal precisely on the record regardless of how the test is named or described. I am exercising my constitutional right to refuse. Knowing. Voluntary. On camera. A legal decision made with full awareness. Not confusion, not fear, not avoidance. Courts treat knowing refusals differently than panicked refusals, and this language establishes which kind yours is. Am I free to go, or am I being detained? This is the legal hinge. It forces a declaration on camera. Either the officer releases you and the encounter ends, or he commits to detaining you and is legally required to articulate specific, independent, articulable reasonable suspicion that exists entirely apart from your refusal to perform voluntary tests. He cannot use your refusal as the basis of detention. Courts have been explicit. That question moves the burden back to him. On the record, on camera, exactly where the Constitution puts it. The officer is going to push back. At a 5-test stop, the pushback is more sustained than at a single test encounter because the officer has invested more in the sequence and because the stakes of losing your participation are higher. Know every line before you hear it. If the officer says, I just need to check a few things and we can get you on your way, this framing presents the test battery as a mutual convenience. It is not. The tests are not a path out of the encounter. They are a path into a report. Your response does not change. If the officer says, you already consented to testing when you got your license, implied consent applies to chemical testing after a lawful arrest. It does not apply to the physical roadside evaluation battery you are declining right now. The officer knows the distinction. He is counting on you not knowing it. Your response does not change. Officer, I once again respectfully decline any field sobriety testing or roadside evaluations, and I will not answer further questions without my attorney present. If the officer says, your refusal tells me everything I need to know, this is a pressure tactic designed to make you feel that your silence is more incriminating than a failed test. Courts have held that a refusal to perform voluntary field sobriety tests cannot, standing alone, establish the probable cause required for a DUI arrest. Your refusal is not a confession. Your response does not change. If the officer says, I already have enough to arrest you, the tests are your opportunity to change that. If he had sufficient grounds for arrest, the arrest would already have happened. The request for testing is the acknowledgement that he needs more. Do not give him more. Your response does not change. If the officer orders you to exit the vehicle, comply. Pennsylvania versus Mims is settled law for any lawful traffic stop. Exiting is not consent to testing. The moment any evaluation is mentioned after you are outside the vehicle, your language is identical to what it was before. And if at any point during this encounter handcuffs come out, for words, said once, said clearly, I want an attorney. Everything stops. Nothing else. The body cam is running from the moment the officer's light bar activates. Every word you say, every word you do not say, the tone of your voice, the steadiness of your hands, the clarity of your speech, the way you hold eye contact, all of it is on record. At a 5-test encounter, that footage is longer and more detailed than at a single test stop, which means the impression you make over the full length of the encounter matters even more. Prosecutors do not just show juries the moment of refusal. They show juries the whole encounter. They want the jury to form an impression of who you were that night, and they want that impression to be someone who seemed like they were hiding something. The drivers who come out of a 5-test body cam recording most protected are not the ones who were silent. They are not the ones who were aggressive. They are the ones who were calm, informed, and consistent, who addressed the officer with the same steady, respectful, precise language at the 5th request as at the 1st. Not performing, not rehearsed, composed, because they understood what each test was, understood what the law said about each one, and exercised their rights the same way every time. That consistency is powerful on camera. It reads as someone who knew exactly what they were doing. Because they did. Memorize these before you close this video. When the officer requests any roadside test, any evaluation, any physical or cognitive demonstration, officer, I respectfully decline to perform any field sobriety tests or roadside evaluations. I am exercising my constitutional right to refuse. Am I free to go, or am I being detained? If he pushes, officer, I once again respectfully decline any field sobriety testing or roadside evaluations, and I will not answer further questions without my attorney present. If he orders you out of the vehicle, comply with the exit. Repeat your refusal when any evaluation is mentioned again. If you are placed under arrest, I want an attorney. One response. All 5 tests. Every module in the battery. Every handheld device. Every instruction to close your eyes or follow a pen or walk a line. One response, grounded in constitutional law, case precedent, and the documented scientific limitations of every instrument and evaluation on this list. No argument required. No hostility required. No performance required. Just the words, said once, said calmly, said on record. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances. If this video reached you before you ever stood in those headlights watching an officer reach for a pen or a handheld device, it did exactly what it was built to do. Subscribe to this channel right now, because knowing the 5 tests is one piece of a traffic stop that has a dozen other moments, and every one of those moments has a legal framework and a set of exact words that goes with it. This channel covers every one of them. One scenario, one legal framework, one set of words, built so that when the moment comes, you are not guessing, you are not panicking, and you are not building a 5-module evidentiary case against yourself on the side of a road. Subscribe. Share this video with every driver you know. Someone in your circle is going to see those lights in their mirror, hear the words "step to the back of the vehicle," and have no idea that 5 evidence-building tests are about to begin. What they know in the next 30 seconds will determine what happens for the next 18 months. Make sure they know what the tests are. Make sure they know what the law says. Make sure they know exactly what to say. Stay calm. Stay protected. Stay free.